The United States' unclear crypto policies have led businesses like Ripple to explore investing outside the nation. Brad Garlinghouse has claimed the Ripple CEO advised the U.S. to follow the U.K. and Singapore. How do you think this will affect the cryptocurrency and the U.S. economy? We will answer these questions in today's video. Crypto enthusiasts continue to speculate on the case and its potential outcomes on social media as they await the release of the contentious documents related to the legal battle the United States Securities and Exchange Commission, SEC, was waging against blockchain company Ripple. Indeed, after hearing from defense attorney James K. Philin that Ripple's legal team member Kylie Chisel Kim had withdrawn from the case, the crypto community has speculated that the case may be coming to a close, either through a settlement or a win for one side or the other. Federal Judge Sarah Netburn called out the SEC for its hypocrisy and claimed the agency's attorneys lacked a faithful allegiance to the law in a ruling from July 2022, which pro-Ripple attorney John E. Deaton tweeted about on May 26. To which he added, SEC lawyers can engage in denial all they want as to why the emails were ruled discoverable, but the truth is that had SEC enforcement lawyers honored the truth, the documents would likely not be seeing the light of day come June 13. Referring to the June 13, 2018, speech by former SEC Division Director William Hyman, in which he stated that Ethereum, EUS, was not a security. Furthermore, Attorney Bill Morgan recently emphasized that there are over 20,000 other cryptocurrencies, and SEC Chairman Gary Gensler saying all cryptos except Bitcoin are securities without the SEC investigating most of them is a political statement, not a legal statement. In addition, he said on May 28 that it was essentially misleading and mischievous and designed to cause disruption and uncertainty through Twitter. In his first year leading the SEC EU 2020, he wasn't even saying it. He's saying it now because it fits with his plan. In fact, back in October, Ripple Brad Garlinghouse, who had access to the Hinman papers, told his company's investors that the shamefulness of the SEC's actions would shock everyone when the truth eventually comes out. This was reported by Cryptolaw, Garlinghouse's legal news outlet. Lastly, after the recent court decision addressing the dubious Hinman papers, Garlinghouse expressed his hope that the lawsuit against the SEC will be resolved in weeks and not months in an interview on the margins of the Redefined Tomorrow 2023 virtual conference. In the next several weeks, according to Ripple CEO Brad Garlinghouse, the contentious litigation launched by the U.S. Securities and Exchange Commission, SEC, should come to a conclusion. In contrast to public opinion, which suggested that reaching a decision may take months, Garlinghouse has provided a more rapid time frame. In an interview with Shkebtanks' CEO Mukaya Panik, Garlinghouse made his remarks. Jeremy Allaire, CEO of Circle, Stephen Goldfeder, CEO of Arbitrum, Michael Groniger, CEO of Chainalysis, and Michael Igorov, co-founder of Curve, and many more are participating at Shkebtanks' 4th annual DeFi and Web3 virtual summit. Brad Garlinghouse said that he anticipates a decision in the current dispute with the SEC to be made within weeks rather than months. And indicative of the court's mood, in Garlinghouse's view, is the recent decision of the presiding judge to refuse the securities regulator's petition to seal the notorious Hyman papers. William Hyman, the SEC's former director of corporation finance, declared in 2018 that Ethereum is not a security, and the Hyman papers include internal conversations and speeches linked to Hyman. Given the potential impact on the current action against Ripple, the SEC has tried multiple times to get these records sealed. In addition, Brad Garlinghouse said that the SEC and the Biden administration prioritized politics above sound policy, which drove crypto entrepreneurs and new developments outside of the United States. According to Ripple's CEO, the regulatory environment in the United States is a major factor in the fact that the majority of his company's customers are located outside of the United States. Bob Rass, Sologenic co-founder, tweeted on the SEC's cryptocurrency rules as the Ripple SEC dispute nears its conclusion. Ross said the SEC's strong posture is already having ripple effects on the crypto business. He claims that the agency's classification of practically all digital assets as securities shows a lack of understanding of these unique technology, causing unneeded legal fights for businesses like Ripple. Raz thinks the SEC's aggressive pursuit of crypto ventures, many without justification, has slowed its advancement. He cautions that it might stifle innovation and drive many enterprises overseas. He argues Ripple must deal with this harsh regulatory environment. Raz compares the SEC to a typical legislature applying obsolete rules to a technology it barely understands. He argues that treating digital assets as securities ignores their unique characteristics and possibilities. Raz suggests that the SEC should have created a regulatory framework tailored to these assets. Raz also notes that the Ripple litigation has revealed SEC irregularities. He proposes that not all digital assets are securities. He believes Coinbase may be affected by these developments. Raz urges the SEC to forsake its enforcement, heavy strategy, and adopt a regulatory system that promotes innovation and protects investors. He warns. At the Dubai FinTech Summit, Ripple Labs CEO Brad Garlinghouse announced a $1 billion investment to extend its services. Garlinghouse says Ripple wants to develop organically and via acquisitions beyond cross-border payments and liquidity. Invest in blockchain-friendly markets. CryptoLaw founder and pro-XRP lawyer John Deaton challenged the SEC's claim that William Hinman's 2018 contentious speech was only his opinion. Deaton tweeted yesterday that Hyman's contentious statement was influenced by senior SEC officials and not his own view. The pro-XRP lawyer claims the speech comprises 63 emails and 52 drafts from prominent SEC officials. Deaton commented on his July 2022 tweet on the document's email chain. Deaton revealed last year that Hyman's documents email chain excludes just the ethics office and ethics chief Dane Serrano. Deaton's new tweet drew crypto community responses. Former SEC lawyer Mark Fagel remarked on the article. Fagel reminded Deaton about SEC Notion. Fagel said that any SEC official's comment that was neither an enforcement action or a regulation agreed on by 5 commissioners represents the speaker's opinions alone. He inquired why people don't comprehend SEC's viewpoint. Deaton said that people grasp the notion. He contended that the SEC usually makes transactional arguments, which Judge Sarah Netburn called out. The U.S. District Judge previously accused Commission Counsel of lawlessness. Deaton's new comments emphasize Hinman's 2018 Yahoo Finance All Markets Summit speech issue. In his remarks, Hyman deemed Ethereum and Bitcoin non-securities after Ripple demanded the documentation behind the speech. The crypto community took notice. The SEC's speech-related debates are known as Hyman's papers. After Ripple referenced the paper, the SEC said Hyman's speech represented his view, not the Commission's. Deaton disputes this. The SEC altered its position when Judge Sarah Netburn dismissed its petition to seal the documents. As reported by the Crypto, Basic Judge Annalisa Torres just unsealed Hyman's materials.